Our top lead this evening is something that is bound to be controversial. On the last day of the monsoon session, that is today, Home Minister Amit Shah introduced 3 bills in Parliament to overhaul the country's criminal laws. The move will repeal the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. Now, as per the proposal, the Indian Penal Code will be replaced by a new bill called the Bharatiya Nyaya Sanita 2023. One of the changes being proposed is the recriminalization of adultery via the back door. Now, remember, the archaic and sexist adultery law in India was scrapped by the Supreme Court in 2018 on the grounds of it being downright sexist. It is now making a comeback. We will try and understand that here on the show, and if really this is a comeback for the adultery law. Before that, here is what else is being proposed. Now, one of the many changes being proposed are with respect to mob lynching that has become a big problem and embarrassment for the government. The centre is mulling introducing a provision for capital punishment in mob lynching cases.
अध्यक्ष जी, मैं सदन को आश्वस्त कर सकता हूं कि 1860 से लेकर 2023 पर 23 तक अंग्रेजों ने बनाए, अंग्रेज पार्लियामेंट ने बनाए हुए कानून के आधार पर इस देश की क्रिमिनल जस्टिस सिस्टम चलती रही। इसकी जगह भारतीय आत्मा के साथ ये 3 कानून अब प्रस्तावित होंगे और हमारी क्रिमिनल जस्टिस सिस्टम के अंदर बहुत बड़ा परिवर्तन आएगा।
Another key change being proposed is in the rape laws. Home Minister Amit Shah has announced that the new proposed bill will include a death penalty for the rape of a minor, while the punishment for gang rape has been increased to 20 years or life imprisonment. Meanwhile, there are 2 proposals that are likely to generate much heat. One of these is scrapping of the sedition law. The proposed bill does not have any mention of the word sedition, but it is pretty much the same in spirit. The proposed Section 150 will be applicable for acts of endangering the sovereignty, unity, and integrity of India. And perhaps the most controversial proposal is what appears to be a backdoor entry for recriminalizing adultery. I'm talking about one of the sections in the Bharatiya Nyaya Sanita Bill, which looks very similar to the repealed Section 497, which was the 158-year-old adultery law. Now, remember, the Supreme Court decriminalized adultery in 2018, saying, and I quote, Section 497 treats married women like her husband's property. The Supreme Court had also called out the law for being unequal because only a man could be punished under that adultery law. While making the ruling, the ex-Chief Justice of India, Deepak Mishra, clearly had said that attaching criminality to infidelity is going too far. So essentially what the government has done is repackage the 158-year-old adultery law, dropped the principles on which the law was scrapped by the Supreme Court, and has now presented it today as a proposal. Essentially, to cut a very long story short, this is old wine in a new bottle. Question is, why? And I'm going to put that question to my guests who are joining me this evening. This debate is going to be slightly nuanced because we want to understand what the government is trying to do and why the government is trying to do it. Talish Ray, you're an advocate. You're joining us on the broadcast. Namit Saxena, you're an advocate of the Supreme Court. You're joining us on the broadcast as well. Talish, the way I have understood it, and please feel free to correct me, because there is absolutely no shame in being corrected, and this is a legal matter, and I'm not a lawyer. But by the looks of it, to me, this looks like the government is bringing the adultery law back via the back door, that they want to recriminalize adultery. Is that your sense and reading as well?
To an extent, but not exactly, because you see what Section 83 reads as, the new Section 83 of the Bharatiya Nyaya Sanita reads as, is actually more in keeping with Section 498, which talks again about whoever takes or entices a woman. However, there are a few crucial points that must be kept in mind, because in the new Section 83 that has come about, then what we see is that at this point in time, anybody can be a complainant as opposed to the old Section 497. As also the fact that while there is criminalization that's there, here there could be anybody who could file a complaint. So in as much, there is a fair bit of a difference that we see in the new one. This is more, Section 83 is more in keeping with 498 of the old IPC. That was in any case there. Having said that, it still doesn't take away what was held by the honorable justices in the Joseph Shine case, which talked about basically how these acts which are about women that are being enticed, women who are married who are being enticed, is something that was not in keeping with the fundamental rights that have been given to women under the Constitution. So that is the limited the sense that I get from this particular provision that has come about as of now.
Namit Saxena, what about you? What's your reading of this new section?
See, what this new section does is, as Ms. Ray also pointed out, this is sort of a mixture of what 497 and 498 actually were. See, this expression of having, or this, rather having this primacy of the husband over deciding criminality under 497 is gone. Now, the expression uses whoever, any woman, any other man. So they have, rather kept it as broad as possible. And the grounds on which, Joseph Shine, the Supreme Court's judgment took away 497 from the IPC statute book, those grounds are gone. And, all these expressions that having care on behalf of that man, etc., which were in 498, they are also gone. So what they've done is they've tweaked Article 83 in a manner that, the grounds on which 497 was declared unconstitutional are no more there. So that it, in case it is challenged, it saves, the constitutionality of itself by virtue of, removing whatever was wrong in Section 497. And they have merged what 497 and 498 used to say separately. And now we have one merged article in form of, one merged section in form of Section 83, which, sort of in a manner we can say that sort of, brings back what adultery largely was. Now they've removed the expression that, that the woman will not be, guilty of abetting that adultery. That expression is also gone. The expression consent is gone. The expression connivance is gone. The expression detainment, which was in 498 earlier, is gone in 83. So all these things, they've tweaked it a little, and the punishment they've also slightly changed. Adultery, if you remember, was punishable up to 5 years. This is punishable only up till 2 years with fine, etc. So they've tweaked it in a manner that the principles laid down in Joseph Shine, the Constitution and judgment of the Supreme Court, those principles remain intact, and the constitutionality, in case it is challenge of Section 83, it succeeds on the ground that it is not regressive in nature, it is not sexist in nature, and there is no primacy attached to the opinion of the husband to decide criminality of Section 497. This is what they've broadly done. So this,
but
in my
Talish,
view,
is still
sort
sexist.
Of a mixture of what it's...
Okay, I understand that. But Talish, to my mind, this is still sexist.
It is very heteronormative in terms
Article
of understanding.
83 is still sexist in my view.
Yes, it is. It is. If you look at it, when you're using the term such as whoever entices a woman, as if, women are sitting there and they don't make up their own mind. It doesn't talk about the consent of a woman. It is also, in that sense, very heteronormative when we look at how we are looking at marriage, which is strange because currently, given the fact that we are moving towards marriage equality, especially for the LGBTQI group, where does that get into account when we are looking into somebody complaining about anybody else? So therefore, should a woman take the choice of moving away? It's easy that you can look at it as anyone from anywhere, which is both a man or a woman, whoever has reason to believe can actually complain. And therefore, what we are not taking into account is the consent or the will of the woman involved here, who may have been in such a relationship.
Correct.
So therefore, yes, definitely it is within the overarching patriarchy that the woman here doesn't get to have a say. She may just get into a relationship at some point in time, and that itself becomes problematic, because if you read the wording of it, you're absolutely right, Shreya, because it talks about whoever takes or entices away a woman. And where is the element of enticement coming from? Therefore, where is the element of consent of a woman coming in for? So in that sense, yes, you're absolutely right. It has not done everything that it should have done when we are looking at it. So at some point in time or the other in the future, we do look at it sort of getting challenged, because please remember that where 497 was concerned, which was about adultery. For the first time, it had been challenged long back in 1951 under Yusuf Aziz versus State of Bombay. And it took us that long for it to come across with the Joseph Shine judgment that was later passed. So, there's a fair bit of history that goes. So we'll have to it remains to be seen as to what shape or fashion it will take once it comes into application.
Namit Saxena, proudly today the Home Minister has said under our new Nyaya Sanhita, all our laws will be gender neutral. How's this, proposal 83, I will not even, maybe Article 83 because it's still a proposal. How's this gender neutral? Again, like in the adultery law, even in this only the man can be punished. It may be a consensual relationship, but only a man will be punished, not a woman.
No, not
And what happens to the principle of extreme privacy? There is something called privacy in a marriage. Why does the government want to get into the privacy of someone's marriage?
If you'll see the predecessor sections of Section 83, which is Section 497, and in fact 498 used an expression married woman. So the predecessor of Section 83, these two sections require that there is an institution of marriage. That is why the expression illicit intercourse is being used in this. But when we say this, these are not supposed to be gender neutral laws at all. See, not all laws are supposed to be gender neutral in nature. They have to be laws which were gender specific is one. Second, if you'll see
but
Section 83,
if it is a consensual relationship, Are Baba, when you're talking about relationships, the government, Namit, wants to interfere in what is a private matter between two individuals or four individuals. The government wants to interfere in that. The government has no reason to interfere in it. Secondly, even if you're interfering in it, you're making the law. You're making a law where only a man can be punished. How is it fair?
No, so that is why Section 83 does not say only a man can be punished. See, read it again with me. Whoever takes or entices away any woman, so and so believed to be wife of another man, with the intent that she may have illicit course with any person, or conceals or detains with such intent any other woman shall be punished. So it is not that only a man can be punished under Section 83. Even if a woman takes or entices any wife of any other man, who shall have illicit intercourse with any person. So they have kept it gender neutral to that extent. It is not that only a man will be punished under Section 83. It is also a woman. They can be, a conspiracy. 120B can also be attracted. They can be a couple doing it, a man and a woman jointly doing it. So this is not, but, the victim of this can't be gender neutral. The victim of this is gender specific. So when we read whoever takes or entices, this can't be read in isolation. You have to also read conceals or detains in the third line if you'll see. So there is detainment as well, which, was perimeter with Section 498. What they've done is they've improved, it gender-wise, and the expression married woman in Section 498 is gone. And, the expression take care on behalf of that man, etc. is gone. So there is no institution, there is no, provision in Section 83 that only a man will be punished. It is whoever and any person, that any person can be somebody who does not identify with any gender and somebody who identifies with a particular gender. But the victim of the crime under Section 83 will be gender specific, which is a woman.
No.
So we can't say that it is sexist.
Namit, I don't know. Then we are reading this differently. Namit, then we are reading it differently. Talish, would you want to come in here? And I wonder what you have to say of this. Namit is telling me that that Article 83, 1 minute is gender neutral. I don't see how this is gender neutral, and I'm going to read it for our viewers. I know both of you have read it, so I'm going to read it for our viewers. It says, whoever takes or entices away any woman who is and whom he knows or has reason to believe to be the wife of any other man with intent that she may have illicit intercourse with any person, or conceals or detains with the intent any such woman, shall be punished with imprisonment of either description for a term which may extend to 2 years, with or without fine. Talish, to me, this clearly says that only a man can be punished, not a woman.
Is a woman, but the accused
I
is
think
not
so. Let's
necessarily
listen to Talish.
I think that's what Namit was also saying. Currently,
Namit, give me a minute here.
Anybody can be punished. It could be a man or a woman who can be punished. However, this section has applicability only on women who are being taken or are being enticed. So it does not apply to men, by the way. So you understand there are two parts to it. One, against whom can it be invoked, and who becomes then a criminal under this. those are the two parts. And I think that is exactly what Namit was also saying. So in that sense, no, it doesn't say that any person who may be enticed, who is believed to be a partner or a spouse of another person. It specifically applies for married women here in that sense. Whoever entices any woman who he knows or has reason to believe to be wife of any other man. So it applies only to people who are already in a relationship, who are specifically identified with the gender of women. However, the punishment or the reporting could be either by a man or a woman, inconsequential of whether they're related to such a woman who has been enticed or taken, and it could be done either by a man or a woman. So in that sense, some senses it will also put in jeopardy relationships that people have with married women, which may be also of the same gender. So therefore, I don't think that Namit was saying anything separate. He was saying that it is divided into these two parts. So that understanding is definitely there, that no, it is not, it's not exactly pro women in that sense. This is not something that
Namit Saxena, then the question is why?
No, because
Namit Saxena, the question is why? Why would the government? Why would the point is that the adultery law in this country was a relic of the British Raj, right? It imposed a 158-year-old morality on us. The Supreme Court correctly scrapped it. Says you can't command loyalty in a marriage. In any case, extreme privacy in a marriage, the government cannot infringe on that. The Supreme Court said various things. These were some of the things that they said. My question to you is, why try and reverse what the Supreme Court has done?
See, this is also again settled law. The amendment issued by the court cannot be taken away, but any court's verdict, any judicial review of any provision cannot bar the parliament to re-legislate on something. So what they've done is they've re-legislated, adultery in a tweaked manner, undoing what was done in the 1860 law. This is what they've done, and this is well within their legislative domain. They can very well do it. Whether it falls, against the constitution, even now, is for the courts to judge and for this provision to be passed. It can, undergo changes again. We don't know. But as it stands today, we can't say that this provision is not gender neutral, because the victim of this is gender specific, which would be a married woman, and the accused attached to Section 83 is again gender neutral, who can be anybody.
How is a married woman a victim if she's having a consensual relationship with someone?
So because this
how is a married woman a victim if she's having a consensual relationship with someone?
No, because 497 and 498 are supposed to protect those married women who are not able to take their own stand. See, you have to understand this. You can't, presume that every married woman in the country. This is what the legislative
that is why 497 was scrapped, because it was imposing a 158-year-old morality on us. Are you telling me that women in 21st century India, married women in 21st century India, don't have the agency to take their own decisions? Kya, Namit?
See, that is why I started with that. This is an amalgamation of 497 and 498 both. 498 was not even challenged. 498, till date also it still holds field. That is why these expressions, taking care of a man, detainment, etc., primacy of consent of husband, etc., are gone. But this is what, as Ms. Ray also pointed out, this is sort of inclined towards what 498 said rather than what 497 said. So that is why I said this is an amalgamation. So the reasons on which 497 was said to be bad law are done away with. So we can call it sexist, we can call it, not gender neutral, etc. But, as it seems to be today, because 498 was never scrapped by the Supreme Court also. 498 still holds field, never challenged also. So this is what it says, is that if somebody detains, that is why I read the expression conceals or detains. If somebody detains another man's wife, this is the provision under which he is going to be, booked. So this provision is not supposed to be gender neutral.
No, but it doesn't just say detains, it also says entices. Namit, but it also says entices. What does entice mean? When it is enticing, it is voluntary.
Yes.
It is a voluntary relationship you are having. Talish, I just want you to come in here. Namit's argument is that the government has every right under the constitution to re-legislate. I agree with him. Of course, the government has a right to re-legislate. But just because you have the right doesn't mean you go ahead and do it. What was the need is the question.
Well, I think, overall, that's a much larger question in terms of how these laws are brought about, what they've been done. Let's not also forget that this was a part of the current ruling parties, if you look at their electoral promises, it was to be able to revamp the laws and bring in new laws. And I think the Honorable Home Minister made it very clear in terms of the fact that they are looking at legislating in terms of all the laws that had been, especially the IPC and the CRPC, which had been made by Thomas Macaulay long time back, 160 years back, so to speak. But given that, I think the claim that it is all, it is moving, is it a step forward? I would say yes. Is it a step forward in the right direction is something that I think, Shreya, we'll all take a call when we see how these laws are implemented. Like, for example, a final reading of 83.
Yeah.
One of the things that when I read 83 was, why does it not talk about a married man can being enticed or being detained against their own will? I mean, I would actually sort of look at that if it were truly gender neutral. But then we also acknowledge that we are in a patriarchal society and our laws are by and large rather patriarchal when it comes to this. So it is with that mentality that we move forward. As for the others, there are other sections that seem to be there which are pro-women, which are taking steps. So overall, in its entirety, we will have to see. As to why it has been done, that is something I think that would be best handled in the floor of the parliament. What we know is currently that the bill is where it is, and we're all trying to read up on it to understand how its application would be.
It was great to speak to both of you to get some clarity, because in our newsrooms we were trying to decipher what exactly this Section 83 means, and does it actually mean recriminalizing adultery. Of course, there will be a big and a long debate on the floor of the House, hopefully, if Parliament works in the winter session. But we are hoping for a debate on this so that we hear all sides, probably a greater clarity on what this Section 83 actually means, whether, the Parliament will give it the go-ahead, not give it the go-ahead. For the moment, it was good speaking to the two of you and getting some clarity on it. Talishre, thank you very much. Namit Saxena, thank you very much for joining us as well. On that note, I'm slipping into a quick break on the show. There's much more on the other side. Do stay with us.